And the time is 1:48. And we are on agenda item number 21, presentation from Licensing Department. Is that right?
Thank you.
Give me 2 seconds, let me turn the light on.
Just waiting for some light adjustment.
Sorry, I'm not listening.
All right, I'll go ahead and get started as the lights adjust. I'm Sara Connelly. I'm the manager of the Application and Licensing Services Programs. And I'm going to talk about the process for application for graduates of non-CAPD accredited programs located outside the U.S., also known as foreign graduates. At the March meeting, at the board's request, I presented on the application process for graduates of CAPD accredited programs. And so this is a follow-up to give you the difference between that process and the foreign graduates. So to get started, sorry, where do I point this?
Let's make sure it's on. Different.
Technical difficulty, 1 second.
Just give me a sec.
Oh, I wasn't plugged in.
Let's try.
Good to go? Okay. So, there we go. Yeah. One thing that's not different between the two processes is the reason for the application. The application program is the board's first line of defense in its consumer protection mandate. We ensure that the applicants are minimally competent to practice and safe to be exposed to consumers. And so all of the application requirements lead back to that mandate.
Sorry, can you step back a little bit?
Oh, yes. And so I'm going to go over just some general information before we get into the details of the process. The application requirements are outlined in law and regulation. So the specific application process is provided in materials to the applicants from the board, but the qualification requirements are in law and regulation, so the applicants can get that information there. There's one application, but there's different parts to it. Here I've outlined 3. Examination eligibility, so the applicants apply to the board, and then they need to get eligibility from the board to sit for their exam. For the foreign graduates, they have to perform a clinical service period, and then licensure. There is another component to this process, and that's actually applying to the board, and we'll talk about that later in the presentation. And also the process involves various parties. It's not just between the board and the applicants. There's other parties involved, such as the federation, who administers the exam, the testing centers where the applicants take their exam, DOJ and FBI that we do fingerprinting for background checks on the applicants. The credential evaluation agencies, which determine education equivalency, and clinical sites and instructors for the clinical service requirement. And then as far from a staff's perspective, I want to go over some of the activities that happen on our end. When an application is received, the information is entered into our tracking system. The application is evaluated, and we look to make sure all the requirements are met, and all the we make sure all the paperwork is there. We do exam eligibility. We look at forms for clinical service period. All of that, evaluate that performance, issue the licenses, and respond to all the inquiries during that process, even before and after with the applicants. And this is a continuous process. Our board does assign applications to the analysts, and they work them from cradle to grave, so to speak. So that analyst is with that applicant the entire time, and we see that we have found that it provides efficiency and better service to the applicant because they're not having to explain their situation in different parts if it were to be more compartmentalized. And that is done in other boards, but we have the analyst process the application the entire life. So with that, I'll go into the different parts. I had said 3, but I added the actual application is the first part. So we will start with that. What happens when you need to apply for a license? So I'll go over some general information first. The preferred method of communication with the board is email. So the application will be submitted either online or through paper, and then the board will communicate with the applicants via email unless they request otherwise. We just found it's more efficient, and applicants get their information quicker, and it's just generally a better way to communicate. Application acknowledgement and evaluation follows payment processing. A lot of times applicants will call and say, "You cast my check, but I haven't heard anything." That's because the state's required to process checks and monies within a certain amount of time. So we have to take care of that part first. And then the application will go through the evaluation part. So that's something to keep in mind. The eligibility is processed after application review. This is important for the foreign graduates because with the graduates of the CAPTE accredited programs, we can grant eligibility based on education verification from the school through FSBPT. So we actually don't need the application for licensure for that. We can do that through the Federation. It's all done electronically. With these graduates, we need the application because that also includes their verification of education, which is done from the Credential Evaluation Agency. And we don't have any kind of interface or any way to do that otherwise. So we'd have to have the application first. And then we advise applicants to review all communication from the board just to make sure that they have everything complete. We're asked very often, what do I need to do? Do I have any deficiencies? I want to make sure the process is smooth. We'll let you know. We'll let the applicants know if there's a problem. And just make sure that we ask that they respond timely. The first thing that we ask applicants to do is review all of the requirements. Review your requirements to apply for a license. Go to FSBPT, look at the information for the exams, look at the test date calendar, look at the exam study guides, know what you're getting into. Oftentimes, like the law exam, applicants don't realize that how extensive that exam is. So we tell them, go look at the materials before you get in through the process. Do it early. And just make sure you know what's required of you before you start, and make sure you allow enough time to get everything together. And as we go through this presentation, you'll see why that's important. There's a lot of preparation involved in applying. But if you do the preparation, it makes that process so much easier for both the applicants and the board. I want to talk a little bit about Social Security numbers and immigration. To apply for a license in California, an applicant must have a Social Security number or an individual tax identification number, ITIN. It used to only be a Social Security number, but as of 2016, they also included the ITIN. And so that's on the screen right there. If they do not have this information, if they don't have either of these, then they're not eligible for a license. And this is separate from immigration. The board's authority to collect a Social Security number or an ITIN is actually for tax and family support purposes. So that if a licensee has any issues with those code sections, not paying family support, or they have tax issues, then those agencies would work with our board to get that resolved, and that could affect their license status. It's actually not for identification purposes, although it is used in some areas, and it's widely used like that, but that's not our authority that we have. And the other part of that is the board does not have the authority to make any judgments on immigration. So the board's not going to check to make sure, is this person eligible to work in the U.S.? That's a separate process. All we look for is that they meet the license requirements and that they have a Social Security number or an ITIN for the purposes specified that we have the authority for. The credential evaluation, this is where the applicants, they have to get all of their information from their program, from their school they attended that is not in the U.S., and they have to provide that information to one of these 4 different evaluation agencies. These agencies go through all of that information, and they determine whether or not the applicant's education is equivalent to that in a CAPTE accredited program. And it's going to be equivalent at the time that that applicant graduated from the program, not to the current standard. So this must be done prior to application to the board. So that's all has to be complete before they apply. And the education has to show that they are equivalent. If there's any education deficiencies, the applicant will be required to complete that prior to applying. I don't know, sometimes you'll hear applicants say it took 4 years to get a license from the board. A lot of that time often is applicants having deficiencies in their education, having to go back, fulfill them, and then getting that check, that sign off that they're equivalent, and then they apply for their license. So a lot of that time is not with the board itself, it's actually fulfilling education deficiencies. Some of these agencies do have programs in place to help the applicants fulfill their deficiencies, but that is something the applicant would do on their own. The board doesn't assist in that process. Once the education is evaluated, this is a form the board provides the credential evaluation agencies, and this is what's issued if the education is found to be equivalent. And so this is what will be submitted with the application to show that, yes, they have the education necessary and that's required for a license. And if you see right here on the bottom, there's a T. This is not in color, but on our forms, it's a red T, and that indicates that the applicant passed the TOEFL exam, which is a new requirement. And so the credential evaluation agency will verify that for the board as well. So the TOEFL exam was required as of January 1st, 2014. And these are the current score requirements as of July 1st, 2017. And all of the scores were established for the basis of consumer protection. So this test is required for immigration, but the board determined that different scores were necessary to ensure consumer protection and make sure that the licensee will be able to communicate clearly with the patient. And so these scores were established and based on FSBPT scores. So FSBPT is also using these scores. And they have to all be achieved in one administration. They can't take one, reading from one attempt and then listening from another attempt. They have to achieve the minimum score in one sitting. It's valid for 2 years. And there is an exemption for meeting this requirement, and that's if the applicant has received a bachelor's degree or higher in the U.S. So if they've done additional education in the U.S., then they are not required to sit for the TOEFL exam. Now we're getting into some more basic requirements. Fingerprinting is required of every applicant. And so we ask that the applicants do fingerprinting no earlier than 30 days prior to submitting their application. And this is to make sure that we have current background information when they apply. For the most part, we ask that the applicants use LiveScan. LiveScan is required if you're in California. If you're not in California, you can do a fingerprint card, but there are difficulties with that sometimes processing. So we advise applicants to come to California, complete that process using LiveScan, because you don't have to be a resident. You just have to be in California, because the LiveScan process is just much easier. And we just, ask that they follow certain, requirements. Make sure you request DOJ and FBI. Keep a copy for yourself. It's just some tips on how to make the process smoother. And then what happens? Oh, go ahead.
Or someone who is in another state and they do want to send their application in and get their fingerprinting done. You said that they have to use a certain card. Do they download that off the website and use that?
That's a good question. They actually need to request that from the board.
And what do? Mail it to them?
Yes. So it's actually a hard card. The applicant, we have a certain email address. The applicant emails their information, their address, name and address to the board's email, and then we will issue out a hard fingerprint card and then they complete that where they're, whatever state they're in, mail it back to us, then we send it into DOJ and FBI. So it's a little bit longer because there's some, mail time or manual intervention, whereas live scan, they run it, and it's automatically sent electronically to DOJ and FBI. We get the responses shortly after. It's all pretty much electronic. The application photo, this is required on all the applications as well. We give tips on what a photo should and should not look like. So obviously it can't be blurry. You have to have your whole head, things like that. And so an example of what a photo should look like is a passport style photo. And it should be taken within 30 days of submitting their application. It's safe that everything should be done 30 days prior to applying. It just makes sure everything's current. Nothing will, going back to fingerprints, we actually, with a lot of the automation that's been implemented with the Breeze system, if we don't have current fingerprints, the applicant may have to reprint because we have automated notices to the Department of Justice to say that we're no longer interested in them because we can only, keep them they have to be current. And DOJ only keeps the records for so long. They will get rid of them from their system. So if that automated process takes place before the applicant applies, they'll have to re-fingerprint. So we want them to be proactive, but not too proactive. So things to keep in mind. Reasonable accommodations, the board does offer reasonable accommodations through FSBPT for both the national exam as well as the California law exam. The applicant has to have the board form completed by the person diagnosing them with their condition, as well as the other information that's filled out, submit it to the board. This does impact eligibility for these individuals because the board will actually needs this information prior to granting eligibility. We can't grant eligibility for people who require reasonable accommodation based upon their information just from the school through FSBPT, because we don't get this additional information through that electronic system. So we actually need these forms in first, and then the board will review them, approve the request, and then let the federation know that yes, we would like to have this. We'd like to allow this applicant to have these accommodations, and then grant their eligibility. Criminal history records is something else that's really helpful for the applicants to do ahead of time. Criminal history records, or if they're applying from out of state, discipline records, they have to be certified. This is something that cannot be provided online. So we tell the applicants, please go collect this information. It has to be certified, get it all done. And that helps the board a lot. It really is the applicant's responsibility to get this information. If it's not available, if the information's been purged, they can get a letter from either the court and their arresting agency saying they're no longer available, but that, again, has to be certified. So that's a lot of legwork that can be done ahead of time. And it is something that if it's not done, will delay the review of the application, because then the board will need to request that from the applicant. The applicant needs to register for both exams, the national exam and the California law exam. And that is done through the federation. It's all online. They create an account, register for the exam, and pay. And then once they do that, then the notice of eligibility will come to the board through the federation's website. So that's all an online process. And then once all of that prep work is done, you go online to Breeze on our website and complete an application. And everything that they can upload that doesn't have to be certified, which is just the criminal records and the verification of education, those are mailed in following the application, but everything else can be done online as well as paying for the application.
So it seems almost a little backward from what I'm used to. Usually you fill out an application and then start attaching all the things, but it sounds like some of this you do up front, the fingerprinting and the photo maybe.
Yeah, you want to complete all of those things beforehand, so that it is ready to attach when you come to the board to apply.
So you register for the exams before you apply.
Exactly, because then you're in there, you're waiting,
Yeah.
but again, not too early. But it takes a while for, FSBPT will notify the board if someone's been registered for a very long time but hasn't been made eligible. But it's pretty lengthy. So that's why we recommend go ahead, register. So if the application is complete for the board, then the board can go in and grant eligibility, and there's no downtime for that applicant. Yeah.
So when they register for the exam.
Let me give you the microphone so that way, yeah.
I just wanted to give the answer. I know the answer. Just kidding. So when they register for the exam, and they need a reasonable accommodation, are they requesting at the time of registration, or is that something separate they're doing with the board?
Both. Thank you for your question.
Okay.
They do both. So when they register through FSBPT, they will have to request accommodations through them as well. So we will get the form to verify the accommodation, but they will also let FSBPT know that they need that accommodation. So both parties are aware of the request. Thank you.
Hi, Sarah. I have a question about sort of the timeline of preparing to apply.
Okay.
Do we offer any resources to potential applicants as far as 30 days before you apply, now you can get your live scan. If you need reasonable accommodations, be sure to submit the request 45 days before you plan on testing. Or is there any sort of benchmarks we can give them so that they don't get too ahead of themselves or try to submit everything at the last second?
Finding that sweet spot. Yeah, definitely. So currently for foreign educated, we do not, because we're working on it. For the CAPD accredited graduates, we do. We just implemented that, or just released that information. So there is a process diagram, and it gives them, get all this done 30 days prior when they should apply. So we do have that for them, and this is in progress still.
Thank you.
So, yeah, thank you.
Can I say something about that? So I've seen that diagram for the CAPD graduates, and that diagram is fantastic because it's just visual, and you can follow the boxes and follow the line and see what is due for the applicant's responsibility. Then what will the state board be doing? What FSBPT is going to be doing? So the diagram's really helpful. Very helpful.
Thank you for your feedback.
Absolutely. So I could see something like that being beneficial for an educated as well. Yeah.
Any other questions?
Sarah, if somebody doesn't have one of their items when they submit, is it a 30-day window around the date of submission of the application? So they're asked to try to get things done no more than 30 days before, but they also have 30 days on the other side in order to get things done? Or is it, I have 30 days before to be able to get my photo, and when I submitted, I still didn't have my photo, but I'm going to do that tomorrow?
I think I understand. So the preparation part, we do recommend no earlier than 30 days prior. But if there is a deficiency upon application receipt, it goes through the process, gets to the analyst identifies, you still need this. That communication will go out to the applicant, and they will be given a time frame. It's probably around 2 weeks. And then if there's no response, we follow up again. And so that communication will continue, hopefully, until we get that deficiency fulfilled. So it is different. It's not just automatically 30 days again. They actually have 1 year to complete their application in total. Is that?
So I complete my live scan 30 days before I submit my application to you, 20 days before my application gets submitted, but I don't get my photo to you, and you contact me and we need your photo.
Yep. Please respond by this date.
Right. And so I have 365 days in order to be able to get you my photo, but to complete my application. My live scan is still applicable because it was submitted within 30 days beforehand?
Yes.
So we can move forward. Got it.
Yes, exactly.
Thank
So
you very
every
much.
deficiency that is dealt with individually. So we're not going to say, oh, well, you did this before, but you only had this much time. Now it's less on this side. So, go ahead.
However, I don't want to step on. I just want to make a gentle reminder in that regard. Yes, those deficiencies can come in after submission of the initial application. But when you said 365, the hair on the back of my neck stood up. There's actually a regulation that as long as that applicant is engaged in the process, there's that flexibility. But if it's deemed by the board that they're failing to respond or participate in their own application process, just for a sheer, use of administrative resources, we'll close that application and consider it abandoned, right? So when you said, I'm going to wait 365 days to get you my passport style photo, no, that's probably, and that's a bad example because we're hoping that that doesn't happen. But it's not a 30-day fixed time frame. It really is participatory on the applicant's part.
Got ahead of me, Jason. Thank you though.
So if I'm a foreign educated PT and I want to apply for licensure, I'm looking at that list and it looks like I better take care of the credential evaluation first.
Yes.
Yeah.
Get that done. Oh, as far as everything, before everything else?
Well, almost because if there are any deficiencies, it's going to take time to get those taken care of.
Yes.
So, okay.
So yeah, the credential evaluation process can be very lengthy, especially if they have to get records from another country, and so that's a back and forth with the agency. So yes, that would be the first step for the foreign graduates.
Do you ever get any foreign educated PTs who do not have an SSN or an ITIN?
I don't think not in a while. I'd have to ask the analyst, Teresa.
You do get them?
Oh, I stand corrected then.
He wasn't aware that we needed one, so I told him the steps, contact my IRS, maybe you can get it within 30 days. And he couldn't, so we had to close the file and we can't proceed. But within that 1 year, he was able to reapply and he was able to attend his session. He's now an active applicant.
So he was successful. Oh, good.
So I'm gonna try to repeat that with the mic. That we did have an applicant that tried to apply. I'm sorry. Oh yeah. That tried to apply that did not have a social security number, and so unfortunately he was not able to obtain one, and so we had to close the application. But he did. Once he did, he was able to reapply and then start the process. So, yeah. Anything else? Okay. So that's just the summary of how to apply. And then we'll move on to exams. The how to apply is the biggest chunk of this process. It'll go a little bit quicker through the rest of the information. So we're going to talk about exam eligibility and what that means for the foreign graduates. They have to pass both their exams before they can begin their clinical service period. So they apply, are found to have their education's equivalent. Then, okay, we're going to grant your eligibility to sit for the exams. And as we talked about, that information, the education information must come with the application, and eligibility is processed after review of that, not prior. So that's the difference between the foreign and the CAPD accredited graduates. And we're also not able to use alternate pathway for the same reasons as the other, in the sense that we have laws that prohibit the participation in FSPT's alternate pathway. So just a reminder, FSPT has a pathway that allows applicants to sit for the exam, because through FSPT, the whole process is handled through them, not the board. So they would sit for their exams and then apply for licensure. The board would have no involvement. Unfortunately, California is not able to participate in that because we have some provisions in our law that conflict with some of the requirements that FSPPT has put forward. And they have to do with a limit on the number of times you can take the exam for a lifetime. So they actually say that if you don't pass the exam in 6 attempts, you can never take that exam again. And California does not. We actually have a provision that is in conflict with that. And also, if you get a certain amount of scores lower, really low scores, you also would be ineligible from sitting for the exam again. And again, that's in conflict with our laws. So we're not able to participate in that process. And that's for both the foreign educated as well as CAPT graduates. And this general information for the national exam, it's the same. 250 multiple choice questions. It's 5 hours. There's 5 sections of 50 questions. 50 questions don't count because they're being tested. And it's $400. And the applicant can take the exam 3 times in a 12-month period. If for some reason they do sit for the exam 3 times and they are not successful, they will have to skip one of the scheduled testing dates, the fixed date testing dates, wait for that 12-month period to pass, and then register again. For the California law exam, it's also administered by the FSBPT. Yes.
So at that point, sorry, going back. So at that point, the 12-month period, you said after the 12-month period and they don't pass the exam, do they reapply or they're just re-registering?
They'll likely have to reapply
Okay.
with the board, yeah. The California law exam is administered by the Federation as well. It tests the knowledge of the applicants, knowledge of the laws and regulations in California. So this is a test for every applicant to be able to practice here. It's continuous. It does not have fixed date testing like the national exam, so they can take it any time. And it's offered, although it's a California-specific exam, they can take it in any state. It is $65 for the exam and $25 to sit for the testing center. And the study guide is offered by the board. So the board does not offer any study guide information on the national exam, but it does provide the materials for the law exam because they are the laws and regulations in the state. Any questions on that one? So once the applicant sits for their exams, they do not get the scores from the board. They will get them directly from the Federation. And they can actually go on their Federation account and get that in, sorry, I got a little distracted. Get that information through electronically, and it's free for the first 30 days. After that, the applicant will have to pay for their results. There is an additional charge for information on, let's say the applicant fails and they want information about how they did in each section. The FSBPT will provide that information, but the applicant will be charged for it. So that's separate from just their score results. And then the scores are sent to the board electronically as well. So it's all done. It's all automated.
How long after the examination?
About a week. About a week from after they take the exam. So there is a little delay in that. Yes?
For the MBTE law exam is the next day.
There you go. Even quicker. Thank you. Oh, thank you. The MBTE results, the board gets them in a week. For the law exam, the board will get them in 1 day. But allow for some processing time in there. Sometimes it's not always right away. No, you can take the CLE as often as you can take it. There is a waiting period to re-register for it. It's 15 days, but you can continue to take it. So the clinical service period, this is for physical therapists only, applicants only. The physical therapist assistant applicants are not required to complete a clinical service period. And it is a 9-month clinical service. Part of that time can be waived by either taking an ethics course, and that can waive 3 months of the service period, or if the applicant is from out of state and they already have experience working in the U.S., they can waive their clinical service month for month up to the total 9 months. So if you're an endorsement applicant who is educated outside the U.S. in a non-CAPTE accredited program, but you do have a license and you have experience in the U.S., you can provide your work experience and then not have to do any clinical service as part of your California application. The clinical instructor, for those that do have to complete a clinical service period, has to have a current and valid California license and has to be certified by the APTA, as discussed earlier. And the applicant will be known as a physical therapist license applicant during that time. And the applicant is responsible for finding their clinical site and their clinical instructor. And that can be kind of a difficult process for them. The board allows the applicant 1 year just to locate their clinical instructor and site. Some are able to do it quicker than others, but it can take a while. And then here's the requirements for supervision. The licensed applicants do have to be supervised the same as the applicants completing the clinical service period have to be supervised the same way a licensed applicant would under direct and immediate supervision. And then here's the information. So like I talked about, the applicant is required to find the facility. These are the forms the applicant has to submit. It's a notice of intent to supervise. And the board evaluates all the parts of the request. If approved, the board will then notify the applicant, and the applicant will complete or will do their clinical service period. And they have 1 year to complete it. So they have 9 months. There may be something that happens where they can't do a continuous 9 months, but they do have 1 year to complete that. Yeah.
There are some things that an applicant can do to decrease that 9-month time?
Yes. So they can either take a ethics course and waive 3 months of it, and then that would just bring them down to 6 months. That's only, so if they have no other out-of-state experience, that would be their only other option besides completing the entire 9 months. If they do have experience in another state, then they could waive the entire 9 months based upon their experience out of state. Those are the only two options.
So if they were in Nevada and had their supervised clinical practice there, they filled out the form, they would have to fill out that form?
No, that's a good point. No, it would be, licensed experience. So they would be a licensee in Nevada, and they would have practiced there for, let's say, they're even new a year.
Sure.
They submit verification that they've had that practice, or that they've done that. It's a work verification. I apologize, a work verification form, and to demonstrate that they have that experience, and then they won't have to do a clinical. So it does have to be licensed experience. Mm-hmm. The clinical service period, as discussed earlier, is completed on the clinical performance instrument from APTA. This is a graphic of the June 2016 version, although we do require the 1997 version. So I apologize for that. But there's the scale that the applicants are measured on, in addition to marking where they're at performance-wise. The clinical instructor identifies where they're at. They also include comments as to how the applicant is performing. And that is done twice, halfway through the service period and at the end. Like I said, some of the stuff was discussed earlier, but if there's any concerns or any questions the board has about the evaluation of the applicants and their performance, staff will follow up with the clinical instructors to get those ironed out, to get the determination on where the applicant is actually at, if there's any conflicting information. And if the applicant is deemed to be at entry level, and the board concurs with that finding, then they meet that requirement for licensure.
So when a foreign educated PT has completed the supervised clinical practice, do you receive 4 copies of the CPI? Do you receive one for the applicant, and one from the supervising physical therapist for midterm? And then do you receive one for each of them for final? Are you receiving 4?
No, it'd just be one for each.
So they are writing on the same paper? The applicant and the supervisor are writing on the same CPI?
My experience has just been the clinical instructor, but I'm just going to verify with.
So the applicant does not do a self rating?
I believe that's they do it together, but can I double check with the analyst?
Yes, we just received one clinical performance instrument. The packet itself contains it had space for midterm and final for that particular section. So the clinical instructor will complete the midterm and final on the same clinical performance instrument, and we just received the one from the clinical instructor. Often we get questions from applicants if they need to complete one for themselves. We don't require that, so we tell them it's up to you and between the clinical instructor and the applicant if the clinical instructor require the applicant to complete one for their own purpose.
So I would actually say, that it's not a required thing. We're not talking about a student. The use of clinical instructor those words are being used probably inappropriately because this is a supervising physical therapist of a physical therapist. This is somebody else who has been practicing at some level. And the self-evaluation I know is important with students, especially to make sure that they're seeing themselves where they're supposed to be. But this is really information that the board is utilizing. So from the supervising physical therapist, essentially as a report to the board about how that that foreign trade applicant had been performing in clinic. I don't know that I would need to see a self-assessment at that point.
I guess I would agree. There have been some times that I have seen a CI rate a student somewhere and give their comments for justification, and then the student rate themselves somewhere and give their justification for it, and it didn't jive. So I just thought I'd throw that out there.
I would just add to that because we have a requirement that the clinical instructors are APTA certified, that may very well happen as a result of their training, and they might do that with my foreign applicant. We're not aware of it if that happens, nor do we require it. But to say that it doesn't or it does, I'm not really sure. I mean, I could see where, in an instance where they are a new graduate and the CI identifies that, or the supervising physical therapist identifies that, they might see a potential benefit to it and do it. But those times where they've been licensed for a number of years, but their work is flowed in and out, and they can only have a certain amount of months waived, so that they're still doing some of it, that wouldn't be necessary.
Want me to move on? Okay. So that's it for clinical service period. So now we'll wrap up. It's just licensure. And if all those requirements are met, the applicant made it through all of those things, a license is issued within 45 days, and then you can view that on the board's website. Their first licensure period is between 13 and 24 months, and that's dependent upon their birth date and when their license is issued. So it's pretty straightforward, and then that's the entire process. Any questions at this point? And this is pretty much it. So any further discussion or questions? I don't know if you want to do it like this or if you want to turn the lights on.
Yeah, this is good.
Okay.
So I know that you don't have a visual diagram out yet that will help guide foreign educated applicants, but this is even helpful. Is there something like this that they have access to?
No, but well, in the materials now, but we could definitely do something like this.
Yeah.
And maybe in the meantime. Any other questions, comments? All right.
That's very helpful. Thank you, Sarah.
Thank you. Thank you.
Five-minute recess, please. 5-minute recess. We're back on record. It's 2:44.
Madam President, if I may have your
Yes,
your
sir.
attention for a moment.
Yes,
I'd
sir.
like to move that we sort of open back up 1398.26.5 for clarification, perhaps, on the vote that was taken.
And for clarity, that's agenda item 17E.
Okay.
Second.
So it's just to make clear on the actual motion and what we voted on and make sure it is what you
Correct.
are agreeing to.
Yeah.
Okay.
So in the words of one of our dear colleagues, Mr. James Turner, every board has to have someone on it that makes everyone else look good. So here I am, just so I'm clear as to what I voted on during that exchange.
Okay.
If we could have council read back the motion.
Okay, so the motion was, if we're just reading back the prior motion, is approve the proposed regulatory text in Title 16 of CCR Section 1398.26.5. Direct staff to submit the proposed text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the Executive Officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing upon amendments to the regulatory text to be consistent regarding the use of the title physical therapy license applicant versus foreign educated applicant, and consistency in the use of clinical instructor versus supervising physical therapist. So the motion was to essentially approve the text that was before the board with just those two amendments, for those two consistency amendments that had been suggested by Alicia. That was the motion that was brought before the board, voted on and approved. There was another proposal to, the other proposal was to send the regulatory text back to staff to research and draft the possibility of having some kind of sunset provision in the text. That was not the motion that was on the floor and voted on. So did anybody vote thinking that the motion was to send it back to staff and legal counsel to research and prepare a version of the text with that sunset provision? Was there any confusion in the voting?
That's what I thought I voted on.
You thought you voted to send it back?
Yes, I thought the proposal was, I'm getting myself confused. So I sort of was following the logic of Dr. Drummer, and then I'd like to see more data come out after 2 to 3 years of using both instruments side by side so that we can make a more informed decision in the future. I assume that was the motion and not just a proposal.
Okay. Did we capture the votes, or can we re-identify what the votes were?
Before we do that, just to clarify though, I think that's slightly different than what was proposed. So I think what Dr. Dominguez is saying is almost a hybrid between the two, where one was we were not going to move forward today with regulatory language until research was conducted about whether or not we could implement a sunset style clause into the regulatory language. And then the other, just clearly moving ahead today with these proposed amendments. But I think I'm hearing that what you're envisioning is kind of a combination of the two, moving forward today, but then also having a data collection period.
Well, I think I would be more comfortable having voted no.
Okay.
And just sort of letting it play out. Which is what I thought I was doing by voting yes.
Okay. So what was the vote?
Alicia Ben-Amen voted no. TJ Watkins voted aye. Jesus Dominguez voted aye. Daniel Drummer voted no. Katarina Elby voted aye.
Okay. And so had you understood the vote, your vote would have been no to proceed, and send it back to staff to work on some more and to research that proposal.
Correct.
Okay. So I think,
Would have failed.
yeah, so the motion would have failed, but there was that confusion. So I think what we can do is the board, I guess, can vote on whether or not they want to undo this motion that's already passed, whether or not they want to do that and then have a new motion and vote, having clarified that point.
Since Dr. Dominguez voted on something that wasn't what he really wanted, I think we should open up that vote again and do what we need to do, whether it's a revote on this motion or, I don't know, legal, what we would do.
Well, I think I'm looking towards Dr. Drummer on the parliamentary
I'm waiting.
procedure.
So the proper procedure at this point would be, because Dr. Dominguez voted in favor of the motion, a motion to reconsider the motion is where we should be. Somebody who voted in favor of the motion is required to be the one to vote to reconsider. So the first thing would be is a motion and a vote to reconsider. If that motion passes, then we reconsider the original motion.
Okay.
We're back to where we started before any vote was taken.
Yes.
So if the vote to reconsider passes, then we're back to before any vote was done.
I move we reconsider.
Well,
Do I need to?
Yes.
I would like to move to reconsider our vote.
I already beat you to it.
I
You
would
can
second that.
Thank
Yeah.
you.
For the purposes of the record, Dr. Jesus Dominguez motioned and Katarina Ellaby seconded.
No, I moved and he seconded.
Okay.
I moved to reconsider my own motion. Yes.
Dr. Dominguez reopened a conversation without having a motion to reconsider. Ms. Ellaby made the motion to reconsider and Dr. Dominguez then seconded. So we now need to have potential discussion about whether we should reconsider, or we could just move to a vote if there is no discussion about to reconsider. So that's the current motion, the current action that's on the table. And depending on what happens with that,
okay.
then we see where we go.
Any further board discussion? Any public comment?
I think,
Yes.
yeah.
Any public member comment? Yes.
I think, when we insert a sunset clause and it's not something that we usually do, just for the sake of keeping things clean, I think we either hold this, do more research, or as per the original, move forward with amended language. I think the sunset clause in it, because we have the option downstream to do the evaluation either way, as what Jason said earlier today. And we can decide if it's not working to change the to change it again and remove the tool, the pet, from the language.
So the adopted language from the motion was that one or the other could be used.
Yeah.
So we have no comparison capability to do of the PET versus the CPI if we continue down that road.
And we will not really, you see, from this morning's discussion, what I got from that discussion was the outcome ultimately is here we have a foreign student, a foreign student coming through the process, and that's the outcome. And even though there wasn't the research, the tool promises to help the decision-making process because it narrows the scope of discretion So it will make the ability to monitor these decisions more transparent, and what we've now theoretically more consistent and accurate.
I have a question for staff. Without the sunset clause, would that prevent staff from gathering data and comparing
Not at all.
two
In fact,
tools
that
against
is-
each other?
That is one of the things that and Mr. Watkins kind of touched on it. That's something that we would certainly look at anyway. And if we identify that there was inconsistencies, we may bring them to the attention of the board and make that recommendation that regulatory change would be necessary to remove one or the other, in either case. But no, not at all. There's nothing.
Just as a point of clarification, who makes the decision to use one or the other as the language is written here?
In this situation, you have a combination. More than likely, it would be the clinical instructor, because essentially they would have to agree to it.
Supervising physical therapist.
I'm sorry. Thank you, Dr. Drummer.
It's important to remember that these are not students. These are physical therapists. These are people who have been licensed in other places and who are practicing. These are not students who have not had the opportunity to practice at this point.
Or at least a combination thereof.
But my other question was going to be, so as a board, are we comfortable with allowing our supervising therapists allowing them to make that decision of whether or not to use one or the other? Because I don't pretend to put myself in their shoes, but I certainly feel much more comfortable using a tool that I am accustomed to using. So I'm wondering if we're going to get enough supervising therapists to use the PET for us to be able to get some valuable information in terms of how effective or how valid and reliable that instrument is to help us make our decision for licensure.
Just a reminder that the current motion that we have is a motion to reconsider. And before we really move into discussion of the motion itself and what should be done with that motion, we should be deciding whether we want to reconsider or not. Discussion can go around the issue, and whether we should reconsider or not. But.
Any public comment regarding the motion to reconsider the previously adopted language? Hearing none, can we have a roll call vote, please?
Licensure Benamin,
Aye.
TJ Watkins,
Aye.
Jesus Dominguez,
I am voting to reconsider.
Daniel Drummer,
Aye.
Katarina Ellaby,
Aye.
Tanya McMillian. Tanya McMillian is absent. On the vote carries 5-0.
Thank you for. Now, would the board like to have any discussion?
So I believe Dr. Dominguez was mentioning that the clinical instructor, the supervising PT has the discretion which tool they want to use if we adopted this amended language, right? You were concerned that if they were to choose the tool that they have traditionally been using, we wouldn't be gathering enough data to determine side by side which tool works most efficiently. I think we should give them the right to choose which tool they feel they can utilize best to assess, the foreign educated applicant, and not try to sway them to use one or the other. I think that's up to their discretion and their ability to evaluate the applicant.
Point well made. And again, in the spirit of the intention of the tools, I think that's the right way to go. It really should be a clinical judgment on the part of the supervising therapist. I'm just sort of looking at it from more of a little mini study where we would have to control for certain, and standardize the approach so that if you didn't have enough N on the PET side, then your statistics would be sort of non-contributory to your decision. But yeah, I agree.
So I have to say that now I'm confused because it seems like that discussion just led down the road of exactly what is in this proposed language from staff in red with no change. And we just brought this back to reconsider, but it seemed to me that there was no change in what this is going to be now. If I'm wrong, if it's going to, because the new language that's proposed on our paper allows for one or the other.
Right, but we are reconsidering because Dr. Dominguez thought he voted on something that he did not vote on. That's why we.
Right, and my understanding is before we voted on this, before the interesting idea, as it was labeled, not by me, was to consider a potential, some sort of a sunset clause that would require the CI or the supervising physical therapist to perform both the PET and the CPI,
Oh.
and then after 3 years to have that go for 3 years, and then after 3 years we would either remove one, have it sunset out, or we would revisit and decide if we wanted one or the other. That was my thought earlier on. I thought that was the intent.
That is a very interesting
That's a new one.
That's a fascinating thought.
That's what was present. That's what I suggested earlier, and I thought that's what the purpose of this was. And Dr. Dominguez is nodding his head as to.
I apologize. I might have simplified Dr. Drummer's fascinating thought to only including maybe a sunset provision, not understanding that it would be a regulatory requirement for the supervising physical therapist to perform both tools so that we could have a validation test, if you will, between the two tools.
If that was not your interpretation earlier, what can you share what your interpretation was earlier? Because if it might be something simpler or different that may be of interest.
Only simpler in that whatever, like this, as an example, the proposed language they have here today where we were saying that we were offering both options, that authority would only last for a certain period of time. So that we would be forced to revisit the situation at a later date and collect that data and make a decision whether we were going to continue to use that or adjust, removing one or the other. This, my new understanding, that now requires them to use both tools. The only offer of advice that I could give the board is it's very difficult now to find a clinical instructor for foreign applicants. I'm sure that some of the faculty members who are tasked with trying to find clinical instructors under CAPTE auspices have a difficult time. It's 10 times more difficult for foreign trained applicants to find someone. And there's often waiting lists. And it also contributes to our application process and actually lengthens the application process because we're really waiting for them to find somebody that meets the board's approval. So adding that additional layer of a new requirement that they would be doing two tools simultaneously could exacerbate that problem.
And I'm concerned that are we even allowed to set a regulation for the purposes of collecting data to make a final determination? Because
furthermore, could that be perceived as creating a barrier to entry for an educated applicant?
It could. And that's my concern.
Yeah, early on when we first began this conversation, one of the, challenges that I had with the PET, with the actual tool was that it was experimental and in the early stages, and that it was FSBPT's responsibility, since they're rolling it out, to make it enticing for clinical physical therapists to want to use the tool. And we are, and in this, as I understood it earlier today when we were making the motion, was that we will set these two options and then let the market decide. Right now it's leaning towards the old, but maybe FSBPT in their wisdom will also say, okay, we want the tool to be used, so what can we do to help others to, so that the decision is swayed. I am not comfortable with enforcing that or making such a requirement on folks that are doing it voluntarily right now and double their burden to do that service.
Far be it from me to complicate matters further.
We're right there anyway.
So I'll add one more layer of consideration, based on the presentation that you heard. A good portion of this analysis is analyst-driven, application-driven. And you've heard different examples or pathways for foreign educated applicants. As an example, the clinical performance instrument, when they're unable to demonstrate licensed performance in another jurisdiction within the United States. But when they can, we will waive that CPI or that supervised clinical practice requirement month for month based on a form that's filled out by their employer that says, yes, they have worked here under a licensed system, and a resume to prove that as well. So there are different kind of layers to the onion in this consideration that a lot of it is analyst driven. And that's why, I kind of alluded to the difficulty with the CPI, that we are very carefully assessing that application process in each and every form and fashion. So when an applicant and their clinical instructors submit their forms, we go through it rather thoroughly to make sure that, there isn't anything in there that would lead us to believe it isn't as valid as it possibly could be. Whether or not we are going to be able to do an assessment between the two viable options, or I take that back, the two options to determine which ones are viable, is a very difficult thing to do empirically.
And still, I feel like that's not our responsibility. You see, I think that, that there is one tool right now that is working, and we have a tool that promises a lot, but we don't have the data to really support that. So test it. Let the market test it. If we test it, then we will know.
So Jason, your interpretation of this morning's discussion was that some sort of a proviso be attached so that the board would be reconsidering this or would be reviewing this language in a certain period of time.
Twofold, that yes, it would be reconsidering, but that window of opportunity where both options were available would be limited by the nature of the language itself. So effective of the regulation date, but to expire upon such and such date. And that was why I said it was a very interesting idea, because I've not seen that kind of language used in regulatory language. It's typically used in statutory language, but it's intriguing. And I understand its purpose, and I didn't see any real obstacle in the use of those two options because it's just a given period of time. enforcing the use of both options is the only, in the new understanding is the thing that causes me to express those words of caution.
So if we were to move forward with this language, but simply add language that says use of one or the other, the option to use one or the other will sunset or will expire in September of, or after 3 years.
Yeah.
Would expire after 3 years for the board to review.
And in that, I wouldn't, if that is the pleasure of the board, what I would ask the board to do is, motion for staff to do a little bit more research into what the fashion of that language looks like, talk to the Office of Administrative Law and see if those kind of things are acceptable in regulatory language.
Oh, you see that because keeping this clean is kind of how we don't complicate our life. And if we put the sunset clause in it and in the regulatory language, and it's not being a practice of ours, we still have the discretion, if we don't do it, to do it anyway downstream without having to state it, because we can keep this in the background and let these two tools run side by side for however we decide. If the data is going to come in either way, if you want it automatically to sunset after 5 years or whatever period we decide, I think then you have a piece that is outside of what we normally do. And I don't know, someone once said on the board, I had it written down that we have to keep this stuff simple and consistent. When
I was afraid there for a minute.
No, it wasn't. So I want to keep it simple but consistent for, as a guideline for moving forward.
So one of the concerns that I had, and I think Dr. Drummer addressed it rather quickly, was in that consideration of what that regulatory language might look like. I would be hesitant to list a specific date because the review process is lengthy, and it would be hard to determine how long it would take to get the regulation approved to determine what that window of opportunity to enforce both tools would look like. But at the same time, listing in 3 years after the effective date of the regulation might be an issue for the attorneys at the Office of Administrative Law, because that's somewhat unclear to the reader that's unfamiliar with the way regulations are written. Where are they going to go to find the effective date of the regulation to base it off of?
So I think E.O. Kaiser's concern is exactly correct, that if you put in something like within 3 years, OAL might have an issue with clarity there, because putting in a particular date is more clear than having someone looking at the regulation try and do the math to come up with the date. And then the possibility of different readers coming up with different dates. And so what I'd anticipate is that OAL might want a specific date in there. And I think what I've seen is that what you do is when you advance the rulemaking package, you put in like brackets or something like that that says insert date. And then as it makes its way through the rulemaking process, towards the very end, OAL will insert that date, or OAL will give the opportunity to insert that date now that it's known when the package is going to be approved. And then that can happen. That's something, again, we can confirm, but I believe that might be a possibility.
I have a suggestion. Perhaps in the motion to adopt the proposed language, we can direct staff to track the data received from the clinical and, what do they call them? CVIs, as they use the various tools for the next 3 years, instead of putting that in the regs, why doesn't that just be something internal?
If I understand Ms. Ellaby correctly, I don't know that it's necessarily needs to be part of the motion even at that point. I mean, it's a direction that the board could definitely give to staff to do.
So then the original motion that I made a couple hours ago is still relevant? Other members?
Yes.
Is there any public comment? Are you sure, Flores? So,
There's something I'd like to clarify about the prior motion. The prior motion suggested edits to make consistent the use of the title PTLA versus foreign educated applicant. But now that I'm looking at it, which one does the board want to use, PTLA or foreign educated applicant? And I think we can clarify that. And the same thing with the other one, make consistent the use of clinical instructor versus supervising physical therapist.
I think that one is quite clear.
Which one do
I think supervising physical therapist has had a resounding, but I agree. Sawa makes a good point. Between PTLA and foreign applicant, what is the preference?
I'll have to defer to one of the practitioners.
well, the title of this regulation includes the words foreign educated applicants. And I would say I'm fine with that.
I believe in the previous presentation, we heard that foreign trained applicants are not granted PTLA status until they reach a certain point in the process.
That much is true.
And so for consistency with that, then I would say that we need to scrutinize what aspect we're talking about of the applicant at what phase they are in the process. Brooke, could you remind us of when, or do we remember, sorry, Sarah, can you remind us of when a foreign trained applicant attains the status of PTLA? Thank you. So once they're enrolled in the clinical aspect of of the phase, they are PTLAs. Thank you.
Are they no longer a foreign educated applicant? They're both.
It's just a new recognition. And while I didn't catch it before, as I read it now, as a matter of sequence and appropriateness, there's no issue with where we're using the terms physical therapist, licensed applicant, as opposed to using foreign educated applicant.
I know that we understand it, reading it.
Mm-hmm.
I'm concerned if the public or a supervising physical therapist or a foreign educated applicant, if that would cause, confusion, or is there any harm with just using foreign educated applicant? Is there a reason why we need to call them a PTLA at this point in the regulation?
If they are considered both, then it may be better to have them labeled as one or both.
As an example, in sub B, when we're trying to define the meaning of supervision, the use of physical therapist licensed applicant is extremely important. And they wouldn't be able to serve in that regard until after they had met those criteria that was specified by Ms. Conley earlier, that both the clinical site and the clinical instructor have been approved at that point. We don't want to provide any misinformation to the applicant that they can start sooner than that, and I think that's the only issue that I have with replacing the PTLA language with foreign educated applicant. The PTLA really is if you think about it, in parallel with how we use that terminology for CAPTE accredited graduates, it's a privilege that's provided by the board to that applicant to participate in that role.
I was just trying to see if there was a way to prevent confusion amongst the applicants. Ms. Conley, you have a comment?
Thank you. I just want to come up to the mic. In the statute, in the education standards where it requires the clinical service period, it actually does, it says in there the applicant shall be known as licensed applicant at that point. I think that's probably where it fell into the reg then. So I think it's consistency with the statute. So just to add that.
Thank you.
I would like to applaud President Robina Edman for recognizing for having a desire to make regulation understandable by the general population.
Okay, so Council, you have something to add?
Yeah, just that the other proposal of a supervising physical therapist versus clinical instructors, I'm looking at subdivision A. It seems like supervising physical therapist is kind of an umbrella term for both a center coordinator of clinical education, is the center coordinator of clinical education and or clinical instructor. So similar to this other discussion, it seems like there may be some meaning and purpose in the use of the two terms, one being a broader than the other. But I think a little discussion about that would be helpful to clarify.
I would just suggest an edit to include the word credentialed in front of clinical instructor. I think that helps to clarify.
Would
because the CCCE, the Center Coordinator for Clinical Education, oversees the clinical instructors, whether they are credentialed or not. And so that person needs to be credentialed.
What person needs to be credentialed?
The CCCE.
Are we saying that in this regulation?
We're not saying that in the regulation. I think that just by language is what's there.
Remind me again why we're even bringing up a CCCE in this regulation?
The language is already there.
Yeah.
And it says that the period of clinical service shall be certified by at least one supervising physical therapist. The supervising PT is the CCCE and or the CI. And in this case, I think if we add the word credentialed CI, it helps to just further categorize who the supervising PT is, that it doesn't open it up to any CI.
Okay, I'm going to say what I have to say and then forever hold my peace. I'll vote when it's time to vote. So in my experience, I have CIs who've been CIs for 20 years, and I would send all my students to that CI. And when I ask that person, are you credentialed? He says, no. I said, aren't you interested in the, CC units? No, I get them other places. But I would forever send my students there. But he is not credentialed. I have some CIs who are credentialed that I have taken off my list. They've got the APTA credential certification, but I'm not sending my students back there. And so this is just my bone of contention. I'm putting it out there. And if credentialed is in this language, then I'm probably going to oppose it.
But a foreign trained applicant can only be in a clinical experience in California with a credentialed CI. There's no other opportunity for a foreign trained applicant in California to get their time, to get their clinical time, unless it's with a credentialed CI.
Are you referring to the APTA certification as being the credential?
Yes.
Yes.
Okay, so my understanding is that the statute already requires the CCCE to be a certified clinical instructor. I guess a question is does this regulation allow a non-credentialed clinical instructor in that subdivision A where it says and or the clinical instructor, or is that simply saying that the CCE is the certified clinical instructor, if that makes sense?
The last phrase, the last sentence, or the last phrase of C, all clinical instructors must be APTA certified.
So just a point of clarity, the requirement for all clinical instructors to be APTA certified is in regulation. It is not in statute. And it is in the regulation that you are contemplating today.
Thank you, because I was a little confused.
The authorizing statute 2653 that requires the clinical practice says that the applicant shall complete 9 months of clinical service in a location approved by the board under the supervision of a physical therapist licensed by a United States jurisdiction in a manner satisfactory to the board.
So if we wanted to change the requirement for the CI to be credentialed, APTA credentialed, we could consider that now or later or whenever, because it's here in this regulation.
There's no question whether you could or you couldn't. You could, you can. For the purposes of amending the regulation, I'll have to be able to provide an argument or reason for doing so. And that's the struggle that I'm having, just in a very kind of short summary look at that idea. Is traditionally this board's been very adamant about that and implementing that requirement because, again, trying to mimic what we thought was best practices that were in the CAPD standards.
So if you needed to think about that a little more as far as justification, I guess from a board member's perspective, for me to justify it, I would need some data. I would need some really good justification why a physical therapist who's not credentialed could not serve as a foreign educated PT supervising clinical physical therapist.
Agreed. I think because of our deferment to CAPD in the United States system, we leave that to the school setting to be responsible for. And we don't have that advantage in the foreign. And that's my understanding of the nature, the intent of this board historically requiring that all of the foreign, all the clinical instructors providing clinical instruction to foreign applicants have that training because we are now responsible for it. There is no deference. There is no relying on another entity to do something.
I would challenge what is it in that training, that CI training for a physical therapist who is now going to mentor students who are just coming out of school. What is it about that training that we need to require that for our supervising physical therapists of a supervised clinical practice?
It's a very good question.
May I make a suggestion that we table this discussion for a future board meeting? I think we're focusing right now on what evaluation tool we should be using for foreign educated applicants. And I feel like that's a deeper conversation about like who can evaluate them, not necessarily the tool that they would use to evaluate them.
It is a deeper conversation, and I'm with you, and then I'm also on the fence because I can't vote on the tools with that language in this regulation. Well, no, I can vote. And if that's what the board wants to do, then we can move forward with the vote.
Jason, can you remind us how long this language has been in regulation and been active in regulation?
Yes. Assuming that the Westlaw website works for me at this point.
I think it was originally registered in 2004, December 9th, 2004. Jason, you can double check, but December 9th, 2004, operative January 8th, 2005. Recorded in the 2004 register. Though I don't know if it's, the same as what we're looking at here, if there were amendments. It indicates a change without regulatory effect in September of 2015. And that's about it. There was a change without regulatory effect in 2015.
If I recall correctly, the language was operative in 2005, and it included amendments that essentially specified the dates of when the certified clinical instructors would be required. And so you'll see the difference between APTA certification being required for the CCCE effective January 1, 2008, and then for all other clinical instructors, January 1st, 2010, to the best that I can recall. And so I think you can also take from that was kind of a slow-moving change. In 2005, where that was being proposed, we still wanted to give enough time for the system to adjust to that new requirement. And it was also due to, I believe, guidance from the APTA.
Does that help at all, Dr. Drummer?
It does. Thank you.
So any further board discussion? And I would invite any public comment. Any board proposal or motion?
I'd like to ask legal counsel if she received the clarity that you were requesting on the use of supervising physical therapist and clinical instructor and all the terminology.
I'm still a little bit unclear about the necessity of the amendments. So I went through the document and I underlined, every usage of supervising physical therapist and clinical instructor. And then what was the other one?
Physical therapist, licensed applicant, foreign educated applicant.
Let me see. I think it would just be helpful maybe to go through and describe each of the changes, because I'm concerned about, making those changes without actually going through and confirming that there needs to be a change.
Okay, let's go paragraph by paragraph. You want to read it out, Sala?
Sure. So subdivision A, the period of clinical service required by section 2653 of the code shall be certified by at least one supervising physical therapist. Parentheses, the supervising physical therapist is the center coordinator of clinical education and or the clinical instructor, licensed by the board or by a physical therapy licensing authority in another jurisdiction which is accepted by the board. Subdivision B, for the purpose of this regulation, supervision means the supervising physical therapist must be on site in the same facility and available to the physical therapist license applicant to provide assistance with any patient care. Subdivision C, effective January 1st, 2008, the Center Coordinator of Clinical Education, CCCE, must be an American Physical Therapy Association, APTA, certified clinical instructor. Effective January 1st, 2010, all clinical instructors must be APTA certified. Some recommended edits on this one. Center Coordinator of Clinical Education is not capitalized, but it is in subdivision A. So might think about that as a consistency edit. And the same thing with clinical instructor. It is capitalized in subdivision A, but not in subdivision C. So that might be for consideration a consistency edit. Subdivision D, the certification shall be submitted in a report to the board and shall document the supervising physical therapist's determination that the physical therapist license applicant possesses the skills necessary to perform any physical therapy evaluation or any physical therapy procedure of patient care within the California healthcare system. The supervising physical therapist evaluation of the physical therapist license applicant shall be prepared utilizing the physical therapist clinical performance instrument issued by the American Physical Therapy Association in December of 1997, or the Federation of State Boards of Physical Therapy Supervised Clinical Practice Performance Evaluation Tool. The certification shall include 2 evaluations of the physical therapist license applicant's skills. One evaluation shall determine the skill level midway through the period of clinical service, and the other evaluation shall determine the skill level at the end of the clinical service. Both evaluations shall be reported at the end of the period of clinical service. Subdivision E, 3 months of the required 9 months of clinical service shall be waived by the board if the physical therapist license applicant successfully completes a course in law and professional ethics as offered by a post-secondary educational institution, or by successfully completing 4 continuing education units in ethics offered by a continuing education provider recognized by a California healthcare board. And subdivision F, 1 month of clinical service shall be waived for each month of licensed clinical practice in another state up to the required total of 9 months. Reviewing that, and that's what I thought. It was like, am I missing something? I don't see it referring to a foreign educated applicant. It seems to refer throughout to just the physical therapist license applicant, right? Unless I.
But as that language is being read, I think that in each of those circumstances, the most appropriate title is physical therapy license applicant.
And if that were the case, if the board agreed on that, I don't see any changes in the document, because I don't think it goes back and forth other than the title. The title does refer to, so there could be an edit to the title, I suppose. So it depends on which way you want to go. You're either just going to edit the title, or you're going to edit every instance in the body, because foreign educated applicant is not mentioned in the body.
Or we're going to leave it.
Yeah, or that's right, or have the title and then the body.
Yeah. It sounds like that's probably the best thing to do, is to leave it. If everyone else agrees.
I agree, and I'd also capitalize CC, CE, and clinical instructor in that subdivision C.
Also in subdivision C, it says certified credential instructor, and I believe the correct word is credentialed.
Say that one more time. Certified clinical instructor? Is that what you mean?
The word certified after APTA, and the word certified after APTA at the end of the sentence. The clinical instructors aren't certified, they're credentialed. It's just semantics, but that's what they call it.
That's what APTA calls it? Okay. So that's also potential edits to so the necessity argument when drafting the rulemaking package would be to have it essentially match the actual terminology used by APTA to reduce confusion among applicants as to what will meet these requirements.
Okay.
And so regarding the other change, so I think it's decided PTLA versus foreign educated applicant, we're just going to leave it the way it is. the other one, clinical instructor versus supervising physical therapist, that edit, I also am not, I'm not understanding the issue of making consistency edits. I only see clinical instructor mentioned in subdivision A and subdivision C. Those are the only two instances. If anybody caught any others, let me know. But the way it's being used in this regulation, it seems like a CCCE might be a clinical instructor. I mean, it is always a clinical instructor, but a clinical instructor is not necessarily always a CCCE. So they're not the same thing. And then what subdivision C is saying is it's saying that all CCCEs and all clinical instructors have to be credentialed by APTA.
Correct.
And that's been the case since 2010. So to remove any instance of clinical instructor wouldn't be merely a consistency edit. I think it would be eliminating a category of supervising physical therapist.
Yes.
And then with regards to having the regulation only refer to supervising physical therapists, you'd lose that definition of what that means, which are those two categories.
Correct.
And I think the two categories of supervising physical therapists are only ever used in subdivision C. In the rest of the regulation, it just refers to the supervising physical therapist, I believe. And subdivision C, in my interpretation, is that it's just there to clarify that both types of supervising physical therapists have to be APTA credentialed.
Yeah.
So I'm just not. So I guess the way I'm reading it is I don't see the. I guess I just want to clarify whether or not the board actually did want to make any edit in relation to supervising physical therapist versus CI versus CCCE.
No.
Okay. No. Okay.
Now that that's all cleared up, I'd like
Hold
to.
on.
Wait, okay.
There is a left side of the room over here.
My hair down, I have no peripheral vision, so.
The only potential edit would be, as I suggested earlier, in A, where in the end of the parens, where it says and or the clinical instructor, would be to make it say and or the credentialed clinical instructor, to remove any potential question as to whether or not a clinical instructor who was not certified, was not credentialed, could be able to take on this role. It just, in my mind, it just adds further clarification that that CI must be credentialed. Because the CCCE has to be.
The regulation states that clearly both do, but I think that it just adds that point of clarity by being consistent.
I think one question that the board might face if they make that change is going through the OAL review and having the question of necessity appear as to is this edit necessary, which is one of the requirements in order for a regulation, amendments or changes to regulation be approved. And since subdivision C clarifies that effective 2010, all clinical instructors have to be APTA certified, then the necessity of that edit will come up. Though I think the argument that, yes, it's necessary because the clarification might be necessary, it might go towards the element of clarity, which is also another requirement for a regulation to be approved. But that might be a hurdle is what I'm trying to say. And then actually now that I'm talking about it, is there a possibility that you have clinical instructors who are not credentialed if they became clinical instructors before 2008? Do we currently have that situation?
No. So all current clinical instructors have to have received their credentialing
By that time?
by that time. from that time forward.
This is
Excuse me.
clinical instructors who intend to be supervising physical therapists for foreign educated applicants.
Mhm.
There are clinical instructors across the state who are not credentialed, who act as clinical instructors for students who are currently in CAPTE accredited or sometimes not yet CAPTE accredited programs. So there are CIs, clinical instructors, who are not credentialed in the state of California. In my mind, just adding the word credentialed in A helps to provide clarity that it's only the credentialed CIs who this regulation can pertain to.
Would this, so for consistency purposes, if you added and or the credentialed CI, would you have, would you have to do the same thing for the CCCE? So saying the supervising physical therapist is the credentialed CCCE and or the credentialed clinical instructor.
It's my understanding that any individual who is intending to have an appointment in a clinic as a CCCE, that person needs to be credentialed, a credentialed clinical instructor, not just for the foreign trained applicants, but for all student education affiliation sites.
Bless you.
That piece is already there. Schools already require that the CCCE be a credentialed CI.
So you're indicating whether domestic or foreign, all the CCCEs are credentialed, that the reason it would be helpful to add credentialed to clinical instructor is that for domestic, they don't have to be credentialed,
Correct.
but for foreign, they do.
With this regulation for foreign, they do. Correct.
Are we good? You okay?
Yeah, I'm okay. I think definitely, I just wanted to clarify that for the record as to the necessity for the change. I think that's a very helpful explanation.
Thank you.
Further board discussion? And public comment? Any board action?
I'd like to move that we adopt the proposed language as amended. Salwa, you had some extra language you'd like to add to these motions that capture?
So when you say as amended, are you proposing the adding credentialed and also the capitalizations in subdivision C?
Correct.
Okay, so I take a minute and and then read.
Thank you.
Okay, so some suggested motion language: approve the proposed regulatory text in Title 16 CCCR Section 1398.26.5 as amended to add credentialed before clinical instructor in subdivision A and capitalize Center Coordinator of Clinical Education and clinical instructor in subdivision C to be consistent with subdivision A. Direct staff to submit the proposed text to the Director of the Department of Consumer Affairs and the Business, Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing. I actually now say for a hearing, but would the board want to set it for a hearing, or
The language that I had used earlier speaks to whether or not that package receives comments, and if it receives comments, we would set it for hearing. Negative comments, I'm sorry. If there were comments in support, we wouldn't have a hearing. But
So we might actually want to use that language. So if you want to combine the two where that's in there, because we don't want to just say set it for hearing necessarily, especially since it's a non-controversial change. There may not be adverse comments or requests for hearing, so we don't want to set hearing unnecessarily.
I'll pull up that language again.
Yeah.
One second.
And after the capitalizations, if the board still wanted to change the word certified to credentialed clinical instructor,
Alicia, you're talking about in subdivision C on the second line after APTA, and then on the third line, the very last word after APTA.
yes.
I agree.
That was the scenic route.
Around the world.
Everybody wanted to get up, stop the car, and look up.
Don't touch the screen.
So while I was drafting that, was there an additional change or?
After you noted the capitalizations to take place in subdivision C, the a second line after APTA, changing certified to credentialed, and in the third line, the very last word, changing certified to credentialed.
So 2 changes to subdivision C? Okay. Okay, so let me know if this accurately captures the motion. Approve the proposed modified regulatory text presented and amended in Title 16 CCR Section 1398.26.5 with the additional amendments to add credentialed before clinical instructor in subdivision A, change the two uses of the word certified in subdivision C to credentialed, and capitalize center coordinator of clinical education and clinical instructor in subdivision C to be consistent with subdivision A. Direct staff to submit the proposed text to the director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received and no hearing is requested, adopt the proposed regulatory changes as modified.
Second.
Motion by Ms. Ellaby and a second by Mr. Watkins. Any further board discussion? Any public comment? Roll call vote, please.
Alicia Benet-Amen,
No.
TJ Watkins,
Aye.
Jesus Dominguez,
I'm going to vote no.
Daniel Drummer,
Aye.
Katarina Ellaby,
Aye.
Tanya McMillian is absent. 3 ayes, 2 noes. Motion carries 3-2.
I thank my colleagues for indulging me.
All right. Ready to move on?
Shall we?
Yes.
All right, so
How about some water?
I do believe I am at agenda item number 22, application services. I'd like to invite the staff up to the front, please. Thank you for enduring the afternoon with us and being here. And it's great to see you here at our board meeting, and we'd love to hear your names.
Okay, I guess I'm starting.
You can pull the microphone in front of you.
So my name's Angel Otley. I have been with the Physical Therapy Board since July of 2016. I am the applications intake support. Basically, all applications that are received by the board come through me first. I'm the primary contact for our email support. Basically, emails that come through, general questions, I respond to those emails. Also, I monitor and respond to the out-of-state fingerprint hard cards that are received by the board. The Department of Justice prefers fingerprints processed via live scan. However, they make an exception for the board. Out-of-state applicants, just for the fiscal year 2017-18, I processed 922 out-of-state fingerprint cards. And I'm gonna try to go through real quick. Well, with that exception, it basically shows the volume of hard cards received and the importance of having out-of-state, hard cards and applicants.
Thank you for doing that.
Oh, my name is Yura Trent. I've been with the board 2 years as of December. Well, will be 2 years as of December. I am the lead of the applications and maintenance license maintenance services unit, and I review and respond to PT and PTA practice questions and issues related to the physical therapy regulations, and I also process all the new grad applications.
Oh, lucky you. It's a lot.
Yes. So, and in fact, there are 33 accredited PT and PTA schools throughout California, and I am in communication with all of them, and I send out the emails with updating with our new policies and procedures and the Survey Monkey. So thank you for those who responded. And that's about it.
Hello, my name is Valerie Kearney. I'm a staff services analyst. I've been with the board just a little over 3 years now, processing CAPTIA accredited PT and PTA applications from initial review through licensure. Currently, I'm assigned to PT applicants by endorsement, U.S. grads, of course, which they're a little more time consuming. So we have fewer of those, but they take more effort. My little fun fact is that of the 53 PT licensing jurisdictions, that includes all 50 states, DC, Puerto Rico, and the Virgin Islands, there are 210,165 active PT licenses. Now, interestingly, there are 293,990 active licenses in all 53 jurisdictions. That's 83,825 more licenses held by 210,165 PTs. That's about 1/3 of the active population. Those numbers were supplied by FSBPT. They do say they're approximate, and they were last updated December of 2017.
Thank you.
Good afternoon. My name is Paul Harrison. I've been with the board for the last year. September will actually be my first year. So my duties are I pretty much review and license all the PTA applicants. So anybody who applies for a PTA pretty much goes through me. Currently, there are 15 accredited PT programs in California. 10 of these programs were added in the last 7 years, specifically between 2011 and 2015. With the increased number of schools, the board has seen a significant increase in PT applicants. In the fiscal year of 2010-2011, the board received 283 PT applications. In the fiscal year of 2017-2018, the board received 690 PT applications in 7 years, which was an increase of 144%.
Welcome aboard, Paul.
Thank you.
Yeah. Thank you.
Good afternoon. My name is Teresa Gutierrez. I've been with the board for about 9 years now. As you guys were aware, I process non-accredited PT and PTA applications from start to end for both PT and PTA. Sometimes the communication starts way before an application is received, so we're in contact with applicants and it's way before that. Some fun facts: in fiscal year 2017-2018, the PTVC received 285 applications from graduates from non-CAPTE accredited programs. This is about 11% of the total applications received by the board. And it might not seem a lot, but due to the complex of our application process. And also, as requested at a previous meeting, the number of non-accredited PT applicants currently performing their clinical service period is 31, with a few awaiting for eligibility, for approval, I'm sorry. And also in fiscal year 2017-18, 21 non-accredited PT applicants completed their clinical service. That might not seem a lot, yet because of the lengthy process that it takes from start to end.
And so, Sarah, you were saying that each applicant is assigned to an analyst. So is there another analyst besides Teresa?
For non-accredited, no, just me.
Wow. Wow. Thank you.
Thank you.
Just wondering about another fun fact. Are there non-accredited foreign educated PTA programs? Or we take applications from graduates from non-accredited PT programs who are applying to be PTAs instead of being PTs?
That's what we see the most.
So thank you to Application Services for coming up here and introducing yourselves. I really appreciate it. And thank you to the board for allowing that. I'm Sara Connelly. I'm manager of the Application Services program, and I'm just going to go over the statistics.
And how long have you been with the board?
17 years, but in various different capacities. So I started very young.
Aren't you 17?
Yeah. was born into it, raised here. Well, I pretty much was raised here. But anyway, so also I'm just going to go over the materials. In the briefing paper, it talks about, we briefly touched earlier about the fact that the website has been updated with new information for the CAPD accredited graduates. It's pretty extensive, the changes. All of the information that was on the website was consolidated into basically a packet format. And that packet includes a guide to the process, checklists, and all the forms the applicant may need. We're still getting the feedback, like you had mentioned, working with the schools, so we definitely welcome feedback on that. It is new; it's only been out for a couple months now, but we are anxious to see how this goes. So the information was posted, and the website was updated to remove all of the detailed information from the pages themselves, and then just very short links as you move through the process. So it's like 3 clicks into the information. We're hoping that helps the applicants narrow into what they need a little bit easier and faster. That's the biggest update we have recently. We did notify the schools, and like I said, are working with them. As far as the data, we keep seeing increases in applications received. For the CAPD graduates, the foreign educated, it is decreasing, but overall there's still an increase in applications received. And the licenses issued has increased, and I think that's due to some process and staffing changes that we've had that has allowed for that, so greater efficiency. Are there any questions on any of the information or anything else you'd like to know?
22% decrease, is that just the ebb and flow in non-CAPD accredited programs? Licensing?
I don't know. I don't know if there's any other ideas on that.
I've actually heard that it could have been from the change of administration and the outlook of immigration from the administrative cabinet and president.
A trickle-down effect, the policies, yeah. Other than that, as far as us, we don't see any direct correlation to anything otherwise.
Yeah, just normal flow, ebb and flow. But
Statistically speaking, that population is at a certain size where any anomaly can reflect, greatly in the percentage. So
right.
22 down, 22 up. Of course, we're going to try to look at it and see if there's something we can attribute it to, but we're used to seeing that kind of flow.
Okay, that's all. Thank you.
Thank you, sir. Any other further board questions or discussion? Any public comment on application services numbers? Okay. And since you're sitting there, do we want to go right into licensing?
Yes, please. And I'd like to invite Justin Silva from License Maintenance up to introduce himself.
Hello.
Hi, Justin.
Hi, my name is Justin Silva. I have now been here with the board for 2.5 years, literally almost to the day.
Oh.
I'm responsible for processing the address changes, the duplicate certificates, the name changes, return mail, and deficiency forms, if I already said that, and inquiries made by all licensees, the PTs and the PTAs who have questions that are basic and not so basic. And even at times dealing with the licensees face-to-face when they come to the window.
Oh.
That's kind of the gist of what I do.
Wow. It's a big responsibility. Yeah.
Oh, yeah.
Mm-hmm.
Thank you very much.
I can attest to that. That was my job when I came to the board. And that's where the term license maintenance came from, because anything that a licensee needs regarding their license, whether it's name change or address change or questions about did my renewal process or did it not process, and there are a lot of questions.
Yeah, they're not always easy to field, I'm sure.
Sometimes they take quite a bit of research.
Yeah. Thank you.
Oh, yeah, thank you.
Yes.
Happy anniversary.
And although licensing is fairly automated at this point, there's still plenty to do with that. So Dustin's very busy.
I bet.
Yeah.
Yeah.
So then I'll just go into the report if you're ready for that.
Sure.
The licensee population is continuing to grow. We don't see anything abnormal there. And I talk about the address changes, the decrease there. The reason for that, it might be the licensees are using other methods, other avenues to change their address rather than a transaction, and we can't capture that data, which we've talked about before, but it does provide such an efficiency for licensees that we want to, continue to do that, even though we can't collect that data. One thing I do want to talk about is the duplicate license requests, the decrease in that. That is notable for me because the return mail process, we've struggled with how to deal with return mail and the volume that we receive. It wouldn't seem like a big issue, but it actually is. And so we are constantly asking that, well, it's a requirement, but we are trying to remind licensees to update their information because it is a big deal because that's, they get their renewals, that notifications that way, and if the board needs to contact them, it is important that we have updated information. If we don't, we do get return mail in the case of issuing any kind of notices. And like I said, there's been struggles in how to figure out what to do with that. I think we've, with the new automation with Breeze and the efficiency that's brought, and the just being able to house all the information in one electronic location has helped with this. And so return mail comes in, we figure out what to do, evaluate, what's going on with it, and then we can get in touch with the licensee to try to get these issues resolved and get information to the licensee as needed. And then if the licensee contacts us, then we can assist them better because we have all this information at hand ready. And so that represents a big success for us. So, so that was exciting. And then the verification request seems consistent, the same increase that we've seen last year. So nothing, it is increasing, but at the same rate it has been. Are there any questions on this information?
Board questions or discussion? No. Thank you, Sarah. You have a lot on your hands, and we appreciate what you do.
Oh, thank you.
Ton of work. You and your staff. Thank you very much.
It's wonderful. They are the program, so couldn't do it otherwise.
Kudos.
So I'm glad. So like I said, thank you for allowing them to come before you.
Absolutely.
And then for continuing competency, I know that's next.
Yes.
I'm actually going to have Veronica Gutierrez come in and present that.
Okay, thank you.
Thank you.
Thank you.
That's agenda item 24.
Hello, good afternoon.
Hello.
Afternoon.
I'm Veronica Gutierrez, and I've been with the board for 11 years now, with my primary job being conducting the continuing competency audits and working directly with the approval agencies. So today I'll be reporting on the program. We continue to conduct the quarterly audits. If you refer to the audit statistics report on page 280, you'll find that for fiscal year 2017-18 for quarter 3 for physical therapists, those continue to be worked on. However, 124 have passed, 9 have failed, 2 are still pending, and we're awaiting further information from the licensees, with a total of 135 being selected, and we're approximately at a 92% pass rate for the PT so far. For the physical therapist assistants, those have concluded. There was 41 that have passed, 5 that failed, 0 that are pending, for a total of 46 with a pass rate of 89%. So, and since our last board meeting, for those agencies that the recognition was removed, we've gone ahead and updated the website, and so it's reflected on there that they no longer are recognized by the board.
Thank you.
Thank you.
How long did that take?
It was pretty fast. We
Good.
submitted that information over, and the IT department worked with us pretty quickly on that.
Good. Any board member questions or discussion on the report? We aren't too concerned about quarter three PTA pass rate being at 89%. Right? It's still 89%, so hopefully we'll see that go up.
Hopefully.
Yeah.
Yeah, we've gone ahead and selected quarter four also, and those are being worked on. So
Thank you.
we'll be able to report more year-end, fiscal year-end numbers at the next board meeting.
Thank you. Thanks, Veronica. And
Alrighty.
thanks to Yasha, too, who's not here.
Yes.
Yeah. Thank you. both.
Alrighty. Thank you, guys.
And agenda item number 25. I'm sorry. Any public comment on the licensing application continuing competency? None. Thank you. I just called for it right now. Yeah, licensing applications and continuing competence. Yeah, I just lumped them all together. Thank you for reminding me. Okay. So agenda item number 25. Informants performance measures, is that where we are?
Mm-hmm.
Yes.
Staff introductions for the CPS.
Come on down. Hello, good afternoon. Who wants to start? Vincent, you look excited.
Suppose that'll be me.
Yeah.
Hello, everyone.
Hello.
My name is Vincent Azar, and I'm with the Enforcement Unit. I'm an analyst. I do complaint initiation. So all the complaints that come in, I basically start the process. I am also the IT liaison for the board, handling anything IT related, basically. I am the single point of contact for Breeze. It's ongoing, probably be never ending, to be quite honest, because there's always changes. There's always ways to improve, so that's always going to warrant some type of change in the system. So I, coordinate those changes, and sometimes, at times we determine when there's changes are necessary in the system and the best way to go about that within the system. And that's about it. That's what I do.
Big it. You're a spot.
I can think of a couple other things. Endorsements.
Yeah, I process verifications, endorsements. Forgot about that one. Sorry about that.
Resident report guru for the department at this point.
I do create the extracts, so a lot of the statistics that you gather from management, they came from reports that are extracts that I created, pull information out of the database.
What we're seeing here.
Mm-hmm.
Beautiful. Thank
Yeah,
you.
a lot of those numbers. And yeah, I think that's it.
Well, and also thank you for making a good impression, because we've also had feedback yesterday from Karen Nelson about some work that you did for them as well.
Oh, awesome. Thank you.
Hello, board members. I'm David Laxton. I'm with the physical therapy board. I've been with the board for over 12 years now this year, serving in many different capacities. I've been with the Consumer Protection Services for about 5 years now. I handle low-level violations, so adverse action, discipline in other states, cease and desist, unlicensed practice, and I'll help others in their cases every now and then. There's maybe some low-level convictions, stuff like that. Glad to be working in it now. It's a lot more focused rather than being all over the office like he is now. So I'm enjoying it. But yeah, that's me.
Thank you.
Thank you.
Hi, I'm Carol Phelps, and I'm an enforcement analyst with the Consumer Protection Services Unit. That's a mouthful. I handle consumer complaints, so any individual or entity that files a complaint, some are assigned to me. There are other analysts that also do those, but we handle the desk investigation, so sending it out to the Division of Investigation or writing letters, requesting information, communicating with both the complainant and the licensee or facility involved, to the point where we get it to the Attorney General if there's discipline necessary, or we issue a citation in-house, or we close it with closing letters or educational letters type of thing, and up to the point where we send discipline to you for vote as far as final decisions.
The whole enchilada.
The whole thing from start to finish. Yep.
Thank you for your reminders to submit our votes on time.
Okay. And I'm Marnie Kincaid, also with CPS, also an enforcement analyst. I'm primarily working with the applicants that have criminal conviction history. I'm doing some other things as far as some of the continuing competency citations and a few various things. I'm working on the archive project right now. I've been with the board about 1.5 years. I came from another DCA board where I was also doing enforcement, but this is such a great board. Really, really, really love it here.
Fantastic.
Thank
Fantastic. Thank you. Yes. Okay. Any other questions or discussion for CPS? Thank you so much.
Thank you.
And the report.
I have a few analysts that are not here today. I have Beatrice Reynoso. She's been with us for 12 years, about 12 years. Then we have Christy Livramento. She's been with us for about 10 years. And then Monty Martin, he had to leave, but he's been with us about 19 years. So we have a pretty stable staff. First, I would like to also thank Karen Nelson from the DC office for acknowledging Vincent for all his work and assisting others outside of our board. You rarely hear that, so that's really nice to hear somebody acknowledge, give the credit where it's deserved. As far as the report, the stats, I don't have a lot to report. We're pretty, from last year to this year, it seems average. But it's interesting to hear Sara say that our licensing population has grown, continues to grow, but our intake on complaints and discipline is pretty much the same. So that's a good thing. That's good to hear, that the population grows, but we're still pretty steady. So that's good. With the enforcement performance measures report, that's the one that I haven't had for the past few meetings. We went to a meeting last week, Jason and I did, and found out the reason why. The reason why is because they are revamping that report for a more current display, a better display for VO. So where they were hoping to have it, I don't remember when he said.
First quarter of next year, I
First quarter
believe.
of next year. So hopefully we'll have a new report. But all of the information that's on that report is pretty much what I'm giving you here. So there's no difference really. It's just a different format.
Right.
In what it's given.
And the important part about that is where we've been advising the board that we have not received that data from DCA up to this point, is that that's not quite accurate. We were never going to receive that data up to that point. They just hadn't relayed that to us, maybe clearly enough for us to understand. The next reversion of what that report looks like, it's been expressed that it will be much more robust in its reporting. There'll be abilities to drill down into the information a little bit more to kind of fetter out some of the complexities. At some of the things that Elsa and I have tried to display to you as members to explain that while we may not have met a 540-day performance measure and our average is more, 700 days, the important part of that is actually that, 89% of the cases did meet the 540-day, but you do have those anomalies that skew the statistics. And so DCA is doing what they can to kind of provide that same kind of clarity in the next reporting tool.
Any other questions with regards to the attachments?
No. But meeting after meeting, we did see in the past that your unit was meeting the performance measures, and I would just assume that not much has changed, that you're still getting it done.
Mm-hmm.
Yeah. So thank you and your unit for working so hard.
Thank you to staff. They're
Thank
the
you to
ones that do it.
staff. Yeah.
I really appreciate the 5-year performance measure milestone sheet comparing fiscal year to fiscal year. As you mentioned, our population of licensees continues to grow, and it looks like our number of complaints received is decreasing, actually. So we're definitely cleaning house.
Yeah.
Okay. Thank you. Any public comment? Thank you.
He's
Do you
not
want?
here.
Yeah. Do you want to report on?
And I didn't know he was leaving, so.
Agenda item 26, probation monitoring.
With regards to monies, it looks like probationers have completed, so the number of probationers has decreased. We've had less licensees enter Maximus, which is also a good thing. Last year in 16-17, it looks like there was 11. This year we had a total of 4. Other than that, I don't see anything else that stands out. The number of probationers or licensees that have entered probation, that again is pretty steady, so not an increase. Any questions?
Any public comment? Okay, thanks for doing that, Monty. Okay. So. Okay, so let's ask for public comment not on the agenda. Okay. So at this time, we'll ask for public comment that's not on the agenda. Anything you want to talk about? It's just you and us. Thank you for being here today and yesterday. It's nice to have you here. Yes. And nice to have you participate this morning too.
I think an extended even special thanks to Flores for giving an incentive to his students to come and witness, the board's activities at a board meeting. I don't know if you guys kind of caught wind of that, but they're not signing in on a sheet for us in the back room, but they're certainly signing in on a sheet for Mr. Vanderven, because I believe there might be an extra credit incentive that was being applied there. So, and we'll be coming out to Sac State within about 2 weeks, right? So those same students that we saw today will have another chance to leave an impression.
Fantastic. Okay, so let's see. Yes. Any agenda items for future meetings? We will have a meeting on December 5th and 6th, and that's the location still to be determined, but hopefully somewhere in the Bay Area.
Yeah, I was thinking, since we got today we had the dry needling presentation from the one, from physical therapist, even though it was in the, military setting, that maybe just to give me a better purview, and maybe some of the other board members would be interested in getting what is the actual acupuncturist view. And I don't know if that is appropriate, but I would really be interested in getting a full scope of that landscape. maybe a presentation from them, something to that effect.
I'd certainly entertain the idea for a future meeting. I don't know if the next meeting is the best meeting to do it at, but yeah, at a future meeting, absolutely. And if I had any influence in that decision-making process, I'd ask that we do it here in Sacramento and not on the road. So
I agree, and I guess the difference would be that we were approached by this group to do this presentation, but to get a group of acupuncturists or a presentation, we would have to maybe solicit that.
I don't know. After having said that today on a webcast, we might receive a request. So
Okay.
I just thought that today's presentation was very helpful in kind of shed some light on that topic that is being conceptual for me personally. And now it's taking a real turn, a reality turn for me.
Any other agenda items for future meeting from the board? You guys seen all you need to see? No public comment? Any public comment? Okay. So at this point, it looks like we're ready to adjourn this meeting. The time, oh, we're going to go into closed session, sorry, and then we'll come back and adjourn. But it's agenda item 19, sorry. Yep, that's closed session. So we'll go into closed session now.
On the second.
Finish, we'll come back and adjourn the meeting. But will we excuse the webcast then for now?
yeah, I think that you could typically say that you won't be returning back to the webcast.
Okay, we will not be returning back to the webcast.
I believe that's also in the informational notes, right? That if adjournment is the only thing left after closed session, then we will adjourn. We will come back into session, reconvene for the purpose of adjourning, and there will not be a webcast.
Okay, thank you. All right, thank you.